Before we start our discussion, if I may a little bit push you on this question, what measures that the most, or let me put it this way, what measures that the Israeli most afraid of as a result of its settlement policies, boycott or what?
I think what concerns Israel most of all is its leaders being held accountable for policies that they can in no way claim are the actions of, for example, an individual extremist settler or a rogue military officer or so on. I mean, when it comes to the entire planning process that Dr. Ishaq spoke about at length, the argument that this is somehow not the policy of a government, premeditated, deliberate, and systematic. It's the only possible conclusion. And I think the main concern and fear of the Israeli leadership, whether as individuals or as a collective, is being held accountable by the international community, whether politically, economically, or legally, for those actions. That is what I think concerns them the most.
Thank you very much again, Mr. Rabani, for your remarks. I think we are now ready to start our discussion. Participants are most welcome to ask questions or make comments on the presentation that they have heard this afternoon. You will be the first one. We shall take a few minutes comments from the audience at a time, then our speakers will have the opportunity to respond, and we shall continue this way. Please introduce yourself at the beginning and make your intervention as brief as possible. And the first is Mr. Walid Assad. The floor is yours, sir.
أنا وليد عساف.
My name is Walid Asaf, and I am a member of the Anti-Settlement Front. My intervention is on a specific point. All the activities by the settlers and all the construction that is being carried out in the settlement project is not an individual. It's not a private enterprise. It's not even a civil society enterprise or an enterprise carried out by the companies. It is well planned. It starts with the Knesset. The Knesset allocates funds in the Israeli budget. The government then distributes the roles and the responsibilities, starting with the head of the government and the prime minister. And those who cooperate are the ministries of public works, housing, agriculture, the fund on land use, as well as the electricity agency, the water company, as well as the settlement division in the Ministry of Agriculture, as well as the Israeli army and the various generals and military leaders, as well as the administrative authorities which do the planning for the settlements. All this is perfectly official, and there are documents, official documents documenting all this. All this is well planned by the government. Therefore, the responsibility is both individual and collective. The government is responsible, the 7 ministries are responsible, and they deal with the issue of the settlement enterprise together. And we have documents regarding the tenders, the plans to expand settlements, the construction plans for settlement units, the tenders that are given out, the tenders by the electricity and the water companies, the companies that build the roads, The only individual actions that happen are in the outposts, what is called in the silent settlement. There is funding this year of 650 million shekels to the settlement division in the Ministry of Agriculture, and of course this is not publicized. The division funds these outposts for settlers who attack Palestinians. They fund caravans, they fund all kinds of things. All this is not publicized because it is officially illegal. And the units, the housing units, which were built in Rahalin settlement between Nablus and Rapamla, they were built by the Ministry of Housing, although these outposts are illegal and not recognized, whereas in fact they had been planned by the ministry and by the Israeli government, and they were issued permits, construction permits. And some of these outposts were also built without permits on Palestinian land with government orders, including the attacks against the Palestinians. Even those attacks were also officially approved or informally approved. Even the ammunition that is used by the settlers in attacking the Palestinian farmers is ammunition that belongs to the army, the Israeli army, and they receive training by the army, and they are part of the Israeli army reservists. Therefore, I'd like to reaffirm here that the responsibility is that of the government. The main person responsible is the Prime Minister. They have funding that is allocated in the budget, and we have many documents that we will provide you with. Thank you.
Thank you very much, Mr. Asaf. I think he underlined and emphasized that this is what we call it official and systematic Israeli settlement. Would anyone like to take the floor, ask a question? Yes, Ms. Christine Shani. Vous avez la parole, madame.
You have the floor. Thank you, Ambassador, Chairman. I would like to thank all of these speakers this afternoon. Unfortunately, everything they said is all too familiar to me. I chaired the fact-finding commission, which was created by the Human Rights Council in 2012. And the only sad acknowledgement I can make is that the situation has become even worse in the short time between 2012 and 2013. I would therefore like to thank these speakers for this additional clarification. A question came to mind following what Mr. Rabbani said. I support his analysis, stating that a military occupation is not in and of itself contrary to international law. And I also align myself with the question he asks, namely, what is the situation of an extended military occupation? My question would be, what can we do to raise this question at the international level, this issue of an extended military occupation and its legality under the Charter? Would it be through the international courts of justice? Would a legal approach allow us to, if not recognize, at least to analyze the situation of an extended military occupation? Because I think that that is a question that has not been addressed under international law and which really does raise a serious problem of international law and which could be perhaps under the criminal court, for example, to hold Israel accountable. So my question concerns the possible legal approach to allow us to analyze the legal or illegal nature of an extended occupation? Thank you.
Votre question.
Thank you for that question, Ms. Shani.
Je donne la parole à Monsieur Hardy.
Mr. Adi Imses has the floor. Microphone, please.
Thank you very much, Mr. Chairman. Before I offer a view, quite an extended view, on the point that Judge Christine has just mentioned, I'd like to give Moeen an opportunity to answer because the question was put to him. Unless he would like to yield to me, I'm very happy to offer a view. Very well. Thank you, Moeen. The reason why I'd like to offer a view is because that's precisely the point that I'll be raising in my talk tomorrow. So no time like the present to raise it now. I agree with the analysis of Moeen insofar as the issue today in 2015 must be, for all of us, what are the legal consequences of Israel's prolonged military occupation of the state of Palestine, the difference between that being a state over and above some territory allocated to the Palestinians through the connotation occupied Palestinian territory. There are legal consequences to that. What are the legal consequences of a prolonged military occupation of the state of Palestine, which has acquired certain elements of apartheid and colonial practices? I'm now paraphrasing the words of the former UN Special Rapporteur on Human Rights, John Dugard, who urged us in January 2007 to speak to this issue. Now, the question was, what could we do? Well, in my respectful view, efforts must be made, serious efforts must be made, and this means by the state of Palestine and its friends in the Arab group at the United Nations, and perhaps others, to put a question to the International Court of Justice, that question precisely to the International Court of Justice for another advisory opinion. Building on the findings of the 2004 advisory opinion, which was unprecedented as a matter of international jurisprudence on the question of Palestine, you would now remove or shift, if you want, the focus from specific or analysis of specific policies or violations by Israel under relevant bodies of international law, as Maureen mentioned, whether IHL, humanitarian law, or human rights law, or what have you, to look at the broader implications of the sort of sum of all of these violations, looking at the legality of the regime of prolonged occupation of Palestine as such. What are the added value? What would be the added value, rather, of such a thing? Well, it's true. Maureen is quite right that in and of itself, military occupation as a matter of public international law is a legal state of affairs. It isn't problematic. It can be if it's accompanied by certain things. So, for instance, military occupation can be illegal ab initio, that is, from the beginning, if it is the result of armed aggression. That is the use of force that is illegal. And there is a very serious argument that has existed since 1967 that Israel's initial use of force in acquiring the occupied Palestinian territory, what we call the occupied Palestinian territory today, was aggression, and therefore the occupation that resulted was illegal ab initio. Unfortunately, the jury, proverbially, is still out on that question, Mr. Chairman. And so, to the extent that there isn't a meeting of the minds of the members of the international community, the Western states and the Arab states primarily, on this question, it's important for us to raise the question through reference to the International Court of Justice, arguing that, as I say, the sum of Israel's illegal actions embodied in the settlement endeavor from 1967 has rendered, and accompanied by practices of apartheid and colonialism, has rendered Israel's very presence in occupied Palestine an illegality, and therefore there will be consequences at public international law for states, that is, third states, for international organizations, for the state of Palestine, and indeed for the state of Israel, that flow from such a finding. Legal consequences as well as political ones. I'll hold the rest of my thoughts there. Thank you.
Thank you very much, Mr. Amsis. Mr. Rabbani would like to add something on this particular? Yes.
Well, just very briefly, I agree with both comments that I think this is a matter that should be resolved through an advisory opinion by the International Court of Justice. And to give credit where it's due, I'm actually, although I'm not a lawyer, I'm currently working on a manuscript with Norman Finkelstein on this very subject, where the issue is there are certain criteria that transcend military occupation. I mean, if military occupation, as a matter of definition, is a temporary situation, what does it mean when A, you began annexing territory, and B, began settling it not with Air Force bases or anti-aircraft sites, but with, civilian families. And in addition to that, of course, when you can demonstrate that you have refused any good faith negotiations to resolve that situation of occupation. And I think if there's one thing that I presume everyone in this room can agree upon, is that the Oslo process was not a question of good faith negotiations to seek to replace the occupation with a new dispensation. I think the maps that Dr. Ishaq showed us were very clear on that. So again, just to summarize, I think this is a question for another advisory opinion by the International Court of Justice before it's a question for the ICC. And to me personally, what interests me perhaps more than any legal determination is what kind of political consequences would potentially flow from such an opinion. Thank you.
Thank you. I now would like to invite Ambassador Riyad Mansour.
Thank you, Mr. Chairman. I was reluctant to get involved in this discussion because we had an extensive discussion on this issue not too long ago in The Hague with my good friends Ardi and Christina. And also they know very well when we spend many hours dwelling on this issue. And I was personally involved for many years in extensive discussions with my good friend, the Special Rapporteur, both of them, Richard Falk and Dugard, over this specific issue. Of course, the good intentions of those who are suggesting to possibly go for another advisory opinion about the legal ramifications of the prolongation of military occupation, thinking that maybe the ruling will be that this long military occupation is illegal and therefore it has to be terminated. I think that we do not need a ruling of that nature because it is obvious that it is too long and it has to be terminated, and it is governed by international humanitarian law. But also it is very possible that in the midst of the frustration that we are going through, and the articulations of some in the midst of the frustration of this situation, to say that the two-state solution is not a viable solution, and therefore thinking that the issue is a programmatic issue, so therefore let us have the one-state solution as the solution. In reality, if we descend to that kind of a position, then in reality we are capitulating to the fact that the settlements will be accepted as legal, because the struggle will not be a struggle to end the occupation and to end the settlements, to stop the settlement activities, and as many of you suggested, that to go back to the borders of 1967 for our state, which means the evacuation of the settlements. So instead of really intensifying our struggle and using all the tools available to us, including the ruling of the ICJ on the wall and the settlements, which has so many things that are useful, and we should put energy in that direction, we will be investing energy in a direction where it will not produce the results that we want. The issue before us, and we need to focus. Do we need to focus on the issue of finding new ways in order really to stop settlement activities and to make the occupation, particularly the settlement enterprise, as expensive as possible? As many of you have stated that so far the Israeli occupation is cheap and the settlement enterprise is cheap. If that is the correct analysis, which is the correct analysis, then the logical issue would be, how can we use all the tools available to us to make occupation expensive, to make the settlement enterprise as expensive as possible? So we do not need to reinvent the wheel. We need now to shift gears, and that's why we are meeting here in Brussels, the capital of Europe, who are taking bold steps in saying there has to be consequences for the continuation of occupation. The labeling policy, the guidelines, they are opening doors for us to move from the theoretical to more of the practical. And if you want to move into the practical, instead of really wasting so much energy in something that has abstract potential, let us think of practical ways of how we make it so difficult for Israeli leaders to travel anywhere as involved in criminal activities, illegal activities. Let us not only concentrate in Europe in terms of doing all these things, but why can't we ask every country that to deal especially with activist settlers as criminals and to make it illegal for them to travel to any country, even to countries with people with dual citizenship, including those with settlement residents and involved in the settlement activities? Why don't we think collectively of ways to make them be questioned as criminals and to go after them as criminals with a view making the cost of occupation and being involved in the settlement enterprise as expensive as possible? Of course, this is part of what I would be saying at the end of this conference in my concluding remarks. But you pushed me, or ambushed me, I should say, into making some of these thoughts with you, and I think that this is a rich discussion. All of our friends, especially in the legal field, and the good friends that I mentioned, their intentions are good. But let us concentrate on what we have, in order really to get the largest possible results on the issue of settlements and occupation. Our people, until this moment, their program is a program of struggling to end the occupation and for the independence of our state to save the two-state solution. We haven't changed that program. We appeal to all of our friends who are suggesting other ideas with good intentions, including the idea of one-state solution, just also to take into account the discussion among the Palestinian people. It took us 3 years, from 1972 to 74, of debating the issue of moving into the two-state solution in a very democratic way. We are not involved in a discussion of abandoning our program of ending the occupation, fighting against settlements, and saving the two-state solution. We are not engaging, except maybe with certain group of some of our activists and their friends, into dealing with the one-state solution versus the two-state solution. But that is not the discussion among the Palestinian people. If you go to Belain and you try to tell them, forget about pushing the wall to liberate more of your land, and let's start struggling for civil liberties and equality between us and the Israeli citizen or the Jews, then you will not be able to survive for 5 minutes in that village. They have been struggling for 5 years in order to liberate their land, a small piece of land in their village, in the direction of liberating the occupied Palestinian territory and acquiring the independence of the state of Palestine, and therefore saving the two-state solution. I think the discussion is good. but it is out of the focus of what we are doing. Let's focus on what we are doing, which is related to how to make occupation more expensive, how to make the settlement enterprise so expensive, and we have tons of tools available to us. Let's use them effectively. Thank you, Mr. Chairman.
Thank you, Ambassador, for your intervention. I would give the floor first to Mr. Sawan Jabarin.
Thank you, Mr. Chairman. I think this discussion, I agree and disagree with both. I agree with Mu'in on the content of the analysis. And regarding, to go to the International Court of Justice with a new question, maybe here it needs more discussion if it's wise this time to go or not. To see the benefits from that, all of these things, we have to take in our account before, because this discussion is not new. And let me disagree with Dr. Mansour, because we had this discussion even before, years ago. And he said the same thing regarding the one-state solution. I don't think the intention behind is, or in any way to lead to that. One, with the frame of the occupation, there is practices of apartheid and colonialism. And I think there is a genuine study a few years ago, and Al-Haq was part of that, mainly on the part of the apartheid. And the title of the study is Beyond Occupation, Colonialism, and Apartheid. Within the frame of occupation, the practices, the nature of the practices is a colonialism and also apartheid. And here the question is, and I think maybe it gives us more new regimes, let me say, legal regimes to fight against the occupation instead of just thinking about one-state solution. That's the case. With the frame of occupation, we can gain more legal argument when it comes, for instance, to colonialism. And that's an issue, for instance. And I look at it like this. And I'm not with the idea to remove completely from the table, the idea of having a new advisor opinion. But the question if it's wise now to go for a new advisor opinion or not. What's about the previous one? And we had this discussion, for instance, and some of them, like Shabas, he said to us, maybe I'm not with the idea to go now to ask a new question. It's good, for instance, to focus on the 2004 advisor opinion, more than to have a new one. But I think in our narrative, as illegal organizations, legal scholars, it's good, for instance, to start addressing and analyzing what's going on in Palestine. It's not enough to say that this is an occupation and that's full stop. What's the nature of this occupation? Is it an ordinary occupation that mentioned, for instance, in the legal and the treaties and the Geneva Conventions and all of these things? What's exactly about the nature of this occupation? Maybe that's the case.
Thank you very much. I do not intend to prolong the discussion on this particular issue. We do still have later on reception in which we can have further discussion on the issue, definitely. But to do justice to others as well, I do believe some others would like to ask question as well. I give the floor, yes, in the following order. The gentleman on the very left, and then Mr. Imsais, Mr. Riyad Mansour. Mr. Rabbani, you will have the floor later on, because I will each of you to give a concluding remark and observation. Kindly, yes, the floor is yours.
Just a few brief comments in the wake of Mu'in's presentation and Ambassador Mansour's intervention about the intangibles of occupation from my particularly Israeli perspective. There is a pall hovering over these discussions, and that is a frustration in the inability to elicit accountability from Israel on the subject of occupation, and the inability to generate a genuine and credible political process. And I think that the intangibles talk directly to these issues. There have been periods in which occupation has been a disease in remission. Perhaps it reflects something about the fundamental possible legality of occupation. That period is over. Occupation is metastasizing. It is an aggressive state. What we are witnessing in the West Bank is new. We are seeing the settler ideology DNA injected into governmental bodies, and we're seeing authorities and powers outsourced from government to the settlers. I believe that Israel is a feisty, flawed democracy within the Green Line. What we are seeing is the Israeli rule in the West Bank morphing into a regime. The strongest allies that the people in this room have in making that point are the people in the current Israeli government, because this is a government of what you see is what you get. This is an in-your-face occupation. And that provides opportunities that we did not have in the past, opportunities to convince Israel's strongest allies that occupation is a disease that cannot be tolerated. It need be addressed. And we now have possibilities. We don't have an awful lot to work with these days. The political process is dead in the water. There's no immediate prospect of its resuming. But what is happening today in the West Bank offers us opportunity to widen the support of people who are not willing to countenance the perpetuation of occupation.
Thank you very much. Mr. Imses, Madam Shani, and then Ambassador Riyad Mansour. 2 minutes, s'il vous plaît.
2 minutes, please.
Thank you, Mr. Chairman. I'd like to concur with Shahwan's earlier comments, and for the record, would like to thank Ambassador Mansour for his comments, but for the record, just make it very clear, and reiterating Shahwan's point, that there is no incongruity whatever, as a matter of law or politics, in seeking an additional advisory opinion of the International Court of Justice on the question of prolonged occupation of the state of Palestine. In fact, it sits squarely within the confines of the two-state formula, international humanitarian law governing belligerent occupation. And the idea, of course, would be that once you have a determination that the regime of foreign military occupation that has lasted half a century of Palestine is illegal, there would be political and legal consequences that flow from that. It has no connection to the one-state or two-state or one-state solution at all. And I just wanted to make that clear for the record. I look forward to further conversation with you, Ambassador.
S'il vous plaît, Madam.
Thank you, Ambassador. Chairman. I absolutely agree with Ambassador Mansour. We shouldn't go before the International Courts of Justice because the court has changed in its makeup, and based on what I've seen, it's not even sure that it would hand down the same opinion that it gave in 2004. I'm sorry that that's being contradicted by other panelists, but I asked the question, and I think this is a genuine legal question. I don't think it should go to the International Courts of Justice. This doesn't mean that the states themselves should not begin to wonder about this and ask themselves the question. The more time that passes, the more of a legal question this occupation raises. And this is really the issue that I'm raising, not the issue of going before the Court of Justice. That's too risky.
Sorry for taking the floor again. And also, I want to thank Christina for her clarification. And let me add in this connection, in the intensive discussion over 3 days in The Hague, one of the key judges who was sitting on the International Court of Justice, Judge Khassaoune, who was with us, he cautioned us and he said, I don't advise you to go to the ICJ again because of the composition of the court and because of the complexity of trying to get another answer to a question, including even the prolongation of the occupation and its consequences, because he said that you might not get as strong as of the answer that you've received in 2004. So that's the first further clarification. The other issue, that doesn't mean, of course, that we will not continue seeking all possible legal options. We are opening the door wide open for legal, options. In one hand, we need to go back to the ruling of 2004. There are tons of things that we have not revisited. We should revisit that. And if all of my colleagues who spoke before me, they are advising to go back to it and to utilize the General Assembly and all institutions for revisiting all of the details contained in that ruling, I think that is the correct advice. And, the Palestinian leadership should take that advice very seriously, because there is many things that we can do if we go back to revisit that option. The other thing is that now we have available to us the ICC, which was not available to us before the year 2002. And we are going to the ICC. And one of the big files before the ICC is related, to settlement activities. And if we succeed in creating and in injecting horror and fear in the hearts and minds of Israeli leaders, and as Mr. Walid Assaf said, that this is a policy that starts from the Prime Minister down the line, if we succeed in create some atmosphere of making those who are involved in this war crime to really face in our fight against impunity and to face accountability, we make them really sweat and be afraid to travel and to be labeled as criminals because they are involved in that enterprise, and to concentrate our energies in that direction, I think that we will be using the legal tool appropriately that was not available to us about 13 or 14 years ago. So we are not excluding any of the new tools that are available to us, particularly in the legal field and specifically in the ICC, and also using the previous ruling of the ICJ. So this way we can intensify the usage of the legal options so that we can accomplish the political objective of making this enterprise as expensive as possible and making occupation as expensive as possible, because we are determined to succeed in this battle of ending the occupation and the independence of our state and saving the two-state solutions. Thank you.
Thank you very much, Ambassador. I would like to open the floor for others to pose questions or remarks. Yes, from the Office of the
High Commissioner for Human
High
Rights.
Commissioner for Human Rights, Geneva.
Just a question for the panelists. Thank you for the information, very rich. You've described various aspects, particularly in relation to outposts of policy, of tendering, of planning, of construction, of support as all being part of this process, this regime, as you say, or whatever word you want to use. I'm just wondering, a number have said that recently there's been a trend towards not just the legalisation of outposts, but the retroactive legalisation of outposts. And maybe you mentioned this in your presentation, but I'm just wondering what your views are, how that, if that is a development, if it's true, and how that would play into the picture that you're presenting. Clearly there's an incentivization issue there in terms of if you know that your outpost has a good chance of being not just legalised but retroactively legalised. I'd just like your thoughts on that. Thank you.
Thank you very much. Would any other delegation like to take the floor? I think I recognize Mr. Joseph Sala, Habitat International Coalition.
Thank you. I represent a collection of civil society organizations, And I think it's incumbent upon me to adhere to a promise that we have also made to our civil society counterparts in Palestine on the subject of this conference, and that is never to use the term settlement again. For one very clear reason: settlement is a euphemism that is used in human geography and urban development. But the situation that we're facing is one of a series of colonies and colonization. And so I'll use that term. But even in international law, it is debated whether or not colonization and colonialism are in themselves illegal, although General Assembly resolutions have made it quite clear. There's a methodology for determining what constitutes colonization, and the decolonization movement has also put those principles into operation. But if we were in fact to use all the tools available to us, there is one very obvious tool in international law, and that is the international prohibition against population transfer. And it is not very debatable at all that we are in fact facing an ongoing process of population transfer, which is not only very strictly prohibited in international law, criminal law, of course, as Moin pointed out, in the Rome Statute. It's both a war crime and a crime against humanity, besides the international human rights law regime. And we are now 23 years after a very extensive study by the UN Subcommission on the Human Rights Dimensions of Population Transfer, which make clear that there's another international law regime that also applies. So I would recommend that we also think of this aspect, not least of all the fact that population transfer has been prosecuted successfully in the Nuremberg international military tribunals at Nuremberg and in the Tokyo tribunals. And we are facing clearly a criminal pattern, not just by the leadership of the political leadership of Israel. And while that may be one of the major fears that those individuals at the command level and the political level may face prosecution, but even a more disturbing, perhaps, threat to Israeli leaders and to Israel in this enterprise is that their ideology is just hanging by a very slender thread based on premises that are not historically substantiated. And although the institutionalized discrimination inside the Green Line and the questions of population transfer have been dealt with by treaty bodies in the United Nations system, the General Assembly has yet to integrate those bits into the political discourse. And it would be advantageous to consider also the crime of population transfer that has been laid out so eloquently before us. Thank you.
Thank you very much. The last on my list is Mr. Abdel Naim Ahmad.
مساء الخير.
Good afternoon. At the outset, I would like to thank you for this generous invitation. I'm a representative of an Egyptian legal organization, advocacy organization. From a humanitarian standpoint, we have seen wars against children, but no advocacy groups have condemned this war against children, inhumane acts, crimes. Entire family has been torched. The media said nothing about this incident. We condemn this act from inside the United Nations, and this has condemned by the state of Palestine. I think it is high time for the Palestinian people to live in freedom and in peace. We should put an end to these continued violations of human rights, and nobody is doing anything to put an end to these acts. And I would like to say that these acts are committed by the colonialist Israelis and not the settlers. So this is a form of colonization and not settlement. The Palestinian children are being terrorized daily. They are having nightmares on a daily basis. Do the world people want their children to go through what the Palestinian children are going through? I think it is high time for Palestine to live in freedom and in peace. It is high time to prosecute this racist enemy that is torturing Palestinian children in front of the very eyes of the world. We have to take them to international criminal courts. And I, in my capacity and on behalf of all human rights organizations, I call for the prosecution of these criminals. I think it is high time for the Palestinian children to live in peace. I would like my protest to be recorded here. And a mother died today of her wounds. What is the world doing now? Now this woman has died. Our children in Egypt are suffering, are having nightmares after what they have witnessed, the crime that has been committed against Dawabshi. The question is, does Israel want peace? I think you have the answer. The answer is in your hands. Today, our children and the children of the world are suffering at the scenes that they are seeing every day of violations. So I wanted my protest to be recorded. I want my condemnation of this act to be recorded. Thank you for this opportunity.
I'm going to give the floor back to our resource person. However, allow me also to abuse my authority being your moderator to also pose two questions, one to Ms. Rima Khalaf. First, with regard to the condition in the settlement, because if you look at the display, the short presentation, the movie outside, we witnessed that there is what we call it a weaponization of Israeli civilian, Israeli settlers. So what is the protection with regard to the Palestinian civilian? They are not armed, but the Israeli settlers, they are equipped with guns and weapons. This is the protection and security of the civilian Palestinian. And my second question to Mr. Isaac, he described the Palestinian occupied territories as the Swiss cheese, taking into account of the current trend, the current speed of the Israeli settlement. What will be the face of the Palestinian occupied territories? Will it be remaining as a Swiss cheese, or it will be in the shape of a bagel or French baguette? So I would like to know from you as well. With this, I would like to give the floor back to Ms. Rima Khalaf, Mr. Hantas, and then Mr. Isaac, and Mr. Rabini at the last.
Thank you very much, Mr. Chairman. In response to your question, let me say that ESCWA prepares annually the report of the Secretary General to the General Assembly on the repercussions of the Israeli occupation on the Palestinian people. Most of those violations are listed, although some, I mean, we usually cover the period until the end of March, and as you can see, Israeli crimes do not end at the end of March, and we can't keep up with the crimes that pop up every day. On settlements, we have documented the lack of protection to Palestinian civilians by the Israelis, and for many of the Palestinian civilians in villages and in other areas where the Palestinian Authority cannot reach and cannot provide protection, they are extremely vulnerable. I have to express admiration for some of the NGOs in those Palestinian villages were without weapons. They just formed small groups to protect the villagers while they are sleeping, so we don't have a recurrence of those scenes of children burned to death while they're still alive. Those are commendable, and I think they deserve international support and deserve a stand by international NGOs in order to highlight their suffering at the hands of the settlers, and to support them. Not, I mean, when I say support, I mean the systemic support against settlements. It's along the lines that Ambassador Mansour said. Settlements are illegal. Products of the settlements are illegal. There should be more action to boycott such products, and to boycott those who supply, whether it is financing or material or construction equipment, or the person, the entity committing the crime, and accomplices for that entity should be boycotted. So this is how we may be able to show our support in order to leave a viable Palestinian state on all the territories that were occupied in 1967. One last comment. Maybe, yes, the two-state solution is the ultimate solution. And the goal should be to establish a Palestinian state along the 67 lines. But we have to be realistic. There should be a fallback position. And that what happens if such a state does not happen? Even if we have a two-state solution, can we allow for continued discrimination within any of these two states? Can we allow a regime in any of the states that discriminates against some of the population based on their religion? I think all those issues, it's not just establishing a Palestinian state, also the rights of non-Jews in the state of Israel is an issue that will need to be addressed within a two-state solution. We believe in states for all their people. No discrimination under international law can be tolerated or accepted, whether it's based on sex, gender, or religion. I'll stop at that. Thank you.
Thank you. Mr. Hunter.
Commenting on what Mr. Assaf said, that the government is responsible, I think there was a decision number 60, whereby the Israeli government has declared the Ministry of the Interior as the entity responsible for these affairs. And this was conveyed later on to the Prime Minister. So whatever the government, whatever the decisions made by the government to build new settlements is a result of a decision by what I call the Settlements Council, named Yesha, in the West Bank.
I will go back to the question of outposts later, but let me say a couple of things first of all. Danny, you remember the court case which Yesh-Din did regarding the quarries? Israel is exploiting the quarries in the West Bank to serve its interests. And there was a petition that this is exploitation and should be stopped. And Michael Sfarad made a very good petition. And the Israeli High Court, it took them 2 years to respond. And the response, if I am not wrong, was as follows. This has been going for so long. It is now prolonged occupation. We cannot do anything about it, but we ask the government not to do any new ones. That's true? Okay. So this answers the one thing. The other thing is the case of Alon Mirey. This is the first settlement which was established by when Shimon Peres was the foreign minister, if I'm not mistaken, in the 70s. And the Israeli High Court at that time decided, this settlement is only temporary, so it should be allowed. And that's about 30 or so years ago. Now, in 2014, Judge Levy came up with his infamous Levy report, which says that settlements are legal, right? And the Israeli High Court decision was wrong. So I'm not a lawyer, but I am trying to explain to you what's going on there. Now, regarding the support they are getting, nobody mentioned how much support they are getting from international NGOs. The settlers are getting, especially from Christian Zionists in the United States. There are several institutions which are helping directly the settlement enterprise. Now, let me commit some blasphemy here. Suppose a European country here, somebody, an NGO, will support a person to go and fight with ISIS or support ISIS. What will be the response of that government? Isn't this the same? When you send money to a settler to go and grab Palestinian land, torch Palestinian children, isn't this considered to be an accomplice to the crime? And how are you going to stop the settlement enterprise if I tell you this figure? We expect that the money the settlers are getting from American individuals, companies, etc., exceeded $100 billion since 1967. Would you consider me a liar? I think I am right, and it even exceeds that figure. So it's much more than the official American support to the Israeli government, what the NGOs are doing. And yet we are not doing anything. Some of them are giving them free tickets per year, pocket money, the opportunity to live in settlements at very reasonable prices. And I did some comparison of land evaluation. You can get a villa in Gush Etzion for about 400,000 shekels. That's how the price is so low. Okay. I know. Before we came here, I think the same day, the Israeli government decided to wipe 64% of all the debts to the settlements. They were given this as a blanket money. Now, regarding the outpost, my dear friend, you asked a very good question. Mr. Waid Asaf mentioned the case of Shivot Rehalim. This was done to legitimize this settlement retroactively. When Talia Sasson issued her famous report about the outposts as a response to the quartet statement which said the Israeli government should dismantle settlement outposts erected since March 2003. Is that right? Israel did not remove one single outpost. Just the opposite. They legitimized them one by one. And the case of Ma'on, Avigal, Reshet, Rehalim, etc., has managed to do them. Let me give you also another piece of information, which I think I am now taking Danny Sidesman's position. Bennett, when he joined this government, the price for him joining the Netanyahu government was that all outposts should be legitimized. And he will get it. He will get all these outposts legitimized. And Israel now, let me warn you about, let me be the doom teller. Wait till October when the issue of the Iran in front of the Congress will subside, you know, we will witness a new hike in the settlement enterprise. And I should have, you should say this, not me, Dan, because you have more information on that. Regarding my expectation, I don't want to be, I don't have a crystal ball in front of me, but let me tell you, I expect that the next 3 to 5 years, we will witness the Swiss cheese continuing with some confidence building measures, some restrictions on some restrictions lifted on mobility, some economic gestures from Israel, more laborers working in Israel in order to absorb the unrest among the Palestinian population and to perhaps postpone the agony until we come up with something else. I don't think it is our role. I think it's the role of the international community. How do you want the Palestinians to judge you? Accomplices, perpetrators, supporters of justice, promoters of justice? This is up to you. And I hope that my Swiss cheese expectations will prove to be wrong. Thank you.
Thank you. Mr. Rabbani?
Thank you. 2 or maybe 3 comments. First of all, regarding what Mr. Shekla said, he's of course entirely right on the proper terminology for these entities. Secondly, in response to Ambassador Mansour, of course, you're right. The 2004 ICJ advisory opinion and the Rome Statute, of course, deal with these issues. Rather, I was raising a different question, and I was raising it as a question, and it's not whether the occupation is no longer legal, but whether can it still be defined as an occupation, as that term is understood in international law, and if not, what are the legal consequences of that? And of course, I understand there are all kinds of tactical considerations that come into it, but I wasn't specifically addressing those. And my final point, regarding the whole issue of the two-state framework, I don't think it should be abandoned for the simple reason that I haven't been persuaded that it's ever been seriously tried. If I, at least speaking for myself, if I did feel it should be abandoned, these issues wouldn't be particularly relevant. Because why would you focus specifically on the West Bank and the Gaza Strip if your purpose is not to promote the two-state framework? Thank you.
Thank you very much, Excellencies. Ladies and gentlemen, this concludes our deliberation of Plenary 1. On behalf of the committee, I would like to express our deep appreciation to the distinguished speakers who share their knowledge and experience. I would also like to thank our discussants who helped the interesting exchange of views. Many thanks also go to those participants who contributed to the discussion and to all of you for your interest and attention.